Good morning, everyone, and thank you for joining us today on this webinar. I think we have already a good number of participants, so we're going to start now. As some of you already aware, by the end of last year, the UAE has or did a major legislative reform and issued a number of new laws. I think it's around 40 laws that were issued. Part of these laws are the intellectual property laws. There is a new copyright law that was issued, as well as a new trademarks law. Today, we're going to focus on the copyright law, and we will talk mainly about it. Before this new law was issued, we had the federal law number 7 of 2002, and it was amended a couple of times. I think the latest was in 2006. So basically, the amendments were quite a long time ago. So maybe it is now the perfect time to do like new reforms and to have like new amendments to the law. And this is also especially with all the changes that's happening in our life, and especially the increased role of technology in our life over the past couple of years. The new law that came into force only last month, which is the federal law number 38 of 2021. After reading it, I would actually consider it as an enhanced version of the old law, because basically it is the same old law, but there has been like new concepts that were introduced into it, and some gaps that were in the previous law were addressed in this new law. So let's say the major things in the old law has stayed there, but there are some new amendments and some new concepts that has been introduced in this new law. So in today's webinar, Mariam and I will be focusing on the significant changes. We will talk about the concepts that has been introduced, or the new concepts that has been introduced to the new law. And we will talk, of course, about the other changes that were made to the law and the effect of these changes to the practice in the UAE. So, okay, let's proceed with the first change. One of the most important issues that we had, or always, it's a main issue, which is the ownership of the copyright. The first question that is always asked is, who is the owner of the copyright? This is the first question you would ask. Under the UAE law, the old law, we had some gaps in terms of the ownership of the copyright. So basically, and that was actually mainly in the employment relationship, because, sorry, the employment relationship, because basically the old law did not at all address this relationship. It was completely silent about it. So we always had to go to the main concept, which is the author of the work or the creator of the work will be the owner of it. And this, from a practical point of view, has created so many issues. Because, like, when an employee come into work and they sign their contract, yes, their scope of work maybe is cleared, but you would not know what would this employee create throughout the process. And from our practice, Mariam, we had so many examples where, long after the employee leave the company would want to protect their copyright, or they want to enforce their copyright. And at that stage, they would realize that they are not the owners of the copyright, because basically there is no assignment of the copyright from the employee to the employer. And this created so many issues, like you cannot register the work, you cannot enforce it at one point. And many times, even if you want to ask an employee after some time to sign an assignment agreement, they will be questioning it, like, why would I need to sign it? You have to pay me more money. So it becomes like, an issue from a practical point of view. This is the same as well when we talk about commissioned work, because this as well was not addressed under the old law. There are so many commissioned work that it's created, but the ownership will always be for the creator and not for the person who asked for that work or directed. There were so many issues as to the collective work as well, and whether, for example, the work created by an employee can be considered as a collective work because it was directed by the employer, and maybe there are some different employees worked on it, not just one person. So there was like a huge, let's say, unclarity about the ownership in these relationships. Another issue that was created because of the lack of addressing this matter is the fact that the UAE law had an issue with the assignment of future works, where, you cannot assign future works. And this is as well created a problem when the employment agreement included, let's say, an assignment, a clear assignment of the works created by the employee. It was for a future work. So this would be like, okay, this could be void under the law. So this is, again, one of the issues that we have been dealing with all over the years as a gap in the old law. So how is the position in the new law?
So we're really excited that finally, after having so many queries about what to do for a commission and what to do in an employment relationship, and as well, universally under other jurisdictions, there is a universally known concept of work made for hire. So when we saw that in the provision of the new copyright law, we were really excited because now the new copyright law introduced finally the concept of work made for hire, which basically now changes what Russia was discussing under the old copyright law. The default setup of ownership of the work now automatically vests with the party that commissioned the work. So it actually solves so many issues that we had before, because traditionally before, once you know that there's no work for hire provision, you have to still enter into instrument to make sure that proper assignments were made. And that was also complicated because you're also limited to what Russia mentioned about assigning of future works and the number of 5 future works, whatever 5 means in terms of assignments. So now with the new copyright law and the work for made for hire introduction, it does help that the default ownership automatically vests with the party that commissioned the work. It is important, and it's an important concept to be known, because suddenly there's a default ownership change, and it's something that needs to be highlighted. Now, this was not only the changes that were made. In addition to that, there was also for the employer's default ownership. As Asha mentioned, we had issues in employment relationship with employers and trying to find employees to have signed certain agreements and certain assignments. Also, as well, now the default ownership vests with the employer, but that is subject to certain conditions. Now, it's important to note that this is all subject as long as there's no other agreement to the contrary. So now we're talking about the conditions of employment. So how do I do? What do I need to do to make sure that when I have an employee in place, ownership vests with the employer? Now, there are 2 conditions basically that the new law has stipulated. One, that the work has to be related, obviously, to the activities or works of the employer, and it has to be created by a direct or indirect mandate from the employer. There's also the other alternative option, because it's written in the law as an or, basically, that while creating the works, the employee used as well the resources that were made available to, such as the expertise, information, tools, materials, in a way that it does show that this is a work product that should belong to the employer. So basically, obviously, on the other hand, if the employee wishes to retain ownership of their work, it has to be one, unrelated to the employer's work. They do not use the employer's expertise and tools to create the work. And we think that this is a really significant update and changes that we really wanted to spend some time on it and highlight.
Very good. I think one of the things that actually comes to my mind when reading these conditions, let's say, when and taking it from the perspective or from the way how our life is now, like we all do a remote work, kind of the working hours kind of now blurred. Most of us use our own laptops, let's say, and it is our own resources, our own internet. So I am really actually curious to see how would that be interpreted in terms of these conditions, like, how it will be clear, like, the work was conducted, like, within or using the employer resources or not. Within the work of the employee.
Yeah.
So I think these things needs to be considered. And also, Miriam, I think although there is a default position, I think there's still a need to be like really very careful when drafting the employment agreements and including these conditions, because I think it still needs to be like really clarified. Maybe it has to be clarified what is the position of this employee, as creativity is part of their work or not. I think these issues should be or will be clarified by the practice.
Yeah,
maybe.
I think you're right, because the law is still new, so it remains to be seen. I mean, when you're working from home, is that a work considered using work environment or work expertise, work tools? So that's really important. And I think one of the things that employers probably would want to do is to make sure that there's no rule or doubts in interpretation of what is considered using the resources of the employer. So most likely it will be a very clear mandate, and probably that's not to be kept for interpretation. But I think that if you come back to us in a couple of months, we'll probably have different stories from actual real life experiences. So we'll tune in on that.
Yeah. Very good. Okay. I think okay. So moving on to the next issue, and this is actually falling, or it's related to the copyright ownership. As you know, architectural works, whether it's in 2D or 3D, is a work that is protected by copyright, and it is clearly mentioned or listed as one of the works that are protected by copyright. The same concept about the ownership that we have just been discussing about the employment and the commissioned work, it applies here. Like the default ownership is that the architect will be the owner of the work unless agreed otherwise. So in practice, they have to have always within the design contracts, where or who will own the copyright. And if you miss that, or if it was not included, we will go back to the default position, which is the architect. And this in practice could get some issues and problems, like in terms of what if I am the owner and I want to do amendments and I want to do changes to the designs after it is done. So there were again so many issues that it's related to the ownership of the copyright. And again, we're talking in the event that there is no agreement, that there was no clarity in the agreement, so we go back to the default position.
Yeah, so I mean, in that sense, it seems that the new copyright law always knows or feels the pulse that what are the issues that people are probably complaining about, or what are the issues that they've seen, because now in the new copyright law, Again, the architectural works, whether in 2D or 3D, remains protected under the new law. There's no changes that, but the change is the default ownership. So the default ownership in architectural design now vests with the owner of the building, not the creator of the underlying architectural designs. We don't know the reaction for the architects, because maybe they had the leverage in terms of when they were negotiating their contracts, they knew that they were the copyright owners and had default ownership to them, and they would allow perhaps the owner of the building contractually to have the rights, but now the default stand is clear. So the owner of the building, not the creator, is the owner of the copyright to the architectural designs. Again, unless there's an agreement to the contrary. So we'll probably have to see what happens with that. In addition to that as well, that the owner of the building, now that they have vested the default ownership of the copyright, they have the right to undertake modifications or improvements on building, the subject matter of the drawings or the designs. And similar to the work for hire and commissioning, this is also an interesting new development in terms of default ownership. And let's see where that goes as well.
Yeah, it's actually interesting to see, like, a specific article in the law that only addresses this type of ownership, or for this type of work. So
we are getting, I think, some questions, but we promised we'll get back to these at the end of
I
our
can't
session.
see it now, but yeah, definitely for the
We'll come
questions,
to
yes, we will look into it later. Okay. Again, one of the always controversial matters in the copyright law is the assignment of future works. Under the old law, it is void to assign the full intellectual future works, and the law says in a very weird way that it should not be in any ways more than 5 future works. Throughout our experience in the UAE, we have never been able to understand the limitation and the number 5 of the work and what works it is. It has always created a problem, like, what is the 5 works? Would it be like, developments of the original work? Like, sometimes the development or the amendments, it could be like a huge, that could be considered a work. Would that be counted as a 5 work? So it was always a problem, and from a practical point of view, it's really very difficult to keep asking, for example, an employee or a consultant or like a freelancer to keep assigning or signing separate documents for assignments every time there is a work that is issued. This doesn't make sense from a practical point of view, but this was the law. And the problem is that the law, like the effect of it is that the agreement will be void and null. So this is like, it's a big effect on it. So it has been like a huge problem. So for the new law,
it's still vague, but it does solve a little bit. It does remove number 5, so we're really excited about that, because 5 seemed to be a very arbitrary number. We had no idea why 5, and basically it can be interpreted widely or narrowly. But now, basically, number 5 is removed, but basically, while still assignment of all future work is still prohibited, so you can't have a blanket assignment of all future work. They're still permissible now for the author basically to enter into agreements in relation to their future works. Now, we're saying this because this is exactly the provision of the new law. It's still going to be set by the executive regulations, which we're eagerly awaiting, because we need to understand what does it mean basically to permit the author to enter into agreements in relation to their future works. I hope it's not number 6 or 7 and we don't enter into another arbitrary number. So we don't know yet. But as Rasha said, this was a really problematic clause because it was a public order provision. You can't contract yourself out of it when it was 5 works. And if we went back to the previous slides, before there was a default ownership, when the default ownership was with the employee or the person who had done the work commissioned by, you still had to navigate, the employer or the person who commissioned the work had to navigate the restriction on the number 5 as well. And So probably this solved two issues. One, with the default ownership, it solves the issue of trying to figure out what does 5 mean, what is the issue of, the prohibition of future intellectual works assignment. And now with the removal of the number 5 of their future works and giving the executive regulation the power to set what are the perimeters, what are the stipulations to that, I mean, it is promising, but we still don't know what we're going to see.
Well, I hope, the executive regulation look into it from the perspective of certain, limitation, but not putting a specific number. I think, from previous experience, we have looked into the assignment of future work, and from reading actually some court judgments, not necessarily in the UAE, it's not in the UAE, but in other jurisdictions, the limitation on the assignment is usually if it is limited by let's say number of years, by a duration of a contract, for example, this could be sufficient to say that yes, it is limited and it should not be void and null. So I hope this could be in a way taken into consideration, that it should be somehow limited, but not limited with a number, because the number is something, we have seen agreements for 10 years, for example, and it's for 10 years you can have how many a number of works that it goes there. So you cannot just say yes, 5 works. This could be done in 1 week of an agreement for 10 years. So I hope they look into it from a different perspective of limitation, but not in a number of works.
Please don't give us a number. Yeah, that's basically what we want. Yeah.
If anyone hearing. Okay. Another, I would say, interesting amendment to the law is, for the copyright law, there is a list of works that would be considered as protected by copyright. And of course, the list that is included in the law is not an exclusive list. Basically, any other works could be included in it. But these are the main, let's say, works that can be protected under the copyright law. It has always been under the old law, the computer applications, software, database is included in the protection of copyright. The new amendment that is made is the inclusion of smart applications. There is no definition in the law for smart application, but we would say that this is kind of addressing the new technologies that has come into our life, and just kind of an emphasis on that this type of works can be protected as well by copyright. So we would say that it is now clearly included as a type of work that is protected. We have seen it as well in the exploitation of works, specifically with the licensing, where the new law has just added that when you, for example, download the applications or the smart applications, whether it is on your phone or it is on a computer, the minute that you download the application and you agree to the terms, this is going to be considered the license agreement. So you are bound by the license agreement. This is just kind of more of addressing the things in the new word, let's say. Yeah.
And then there's more focus we can see on the smart applications, because it's been referenced in 3 articles in the law. And the other reference, which is related to moral rights. So as some of you may be aware, moral rights is right, you have the right as the author. Even if you assign your financial economic rights, you have the right to have the work attributed to you and right to make sure that it's not distorted. Another right that is given as a moral right is that you have the right to go to the court and ask certain work to be removed from publication if you feel that this is prejudicing your moral rights. Interesting enough, they've excluded smart applications from that. Basically, except for smart applications, an author can actually ask the court to remove their work from publication if it's infringing their moral rights, but they can't do that for works related to smart application and copyright as well, and the computer programs and their applications. For now, I mean, it's interesting to see there's a focus on protection on smart application and computer programs, but the exclusion itself on that particular aspect of moral rights is trying to give a little bit of freedom for the authors or financial holders of those rights, so they don't get prejudiced from the author of the moral rights to ask them to remove them from circulation.
And fair use, as you know, most of you may know that the fair use is basically the limitation or the exceptions to the copyright. And it is always limited because these are exceptions and there are conditions as well for applying the fair use. In general, the fair use under the old UAE law and actually the new, I would say it's almost the same, which is like, the fair use is for the personal use. If you use, if you make a copy for a personal use, most importantly that it should not be for profit or for professional use, backup copies of computer programs, use of works in judicial proceedings, like when you copy from, let's say, from court, from books or from research or from whatever, you can use it within judicial proceedings, preservation of documents, criticism or debate as well. This is considered as well a fair use. The performing for family gathering, broadcasts showing architecture, just like building, and I think also the applied arts as well, and artworks, for educational purposes, public speeches and published articles on public matters. These are all covered within the fair use aspect.
And they didn't change basically. I mean, the enumeration of the permitted acts, basically the new copyright law didn't change. So what Russia just enlisted, these are just examples. They still exist. But what's been added, which is really interesting as well, is because they've added two things. So you have the list of permitted acts, which is on the left side of the slide. But this is not absolute, meaning that it has to be, it is permissible and is considered fair use and not an infringement of copyright as long as they don't conflict with the normal exploitation of the work and they don't unreasonably prejudice the legitimate rights of the right holder. Now, this is, again, it could be very widely interpreted. What I could be considered as prejudicial to my work could be a different interpretation for Russia, for example. So we can see that probably this is going to be a point of much debate where both different parties will use their different ways of interpretation of what they consider as the fair use that could have prejudiced their positions. Now, this isn't really entirely new. This was already from international conventions such as TRIPS Agreement and Berne Convention. And we believe that the legislators wanted to make sure that these are added as well. So it's basically just an addition to that, which was already international conventions. In addition to that, there's an additional very, very helpful provision that's related to fair use, which has to do with disabled users, which basically is for persons with blindness or visual impairment. It's just basically allowing those individuals to be able to have an accessible format copy that allows them basically to be able to access the work because they're not being able to access it in a normal format such as other people can. And this would allow them, those with visual or physical impairment, to access that work. So obviously in normal circumstances, you are basically altering or the actual copy or the actual version, and they wanted to make sure that this alteration does not trigger any violation of the copyright law, and that is why this provision was added.
Yeah, and just to add to Miriam's point on the disabled users, this is again came from the WIPO administered agreement I think it's Marrakesh Treaty, and the UAE is party to it. So this is as well part of the obligations to include, such exceptions. There is a clear definition in the law for the who are the disabled users, and what is the work or the formats that can be created for them. Again, these are exceptions, so it is always has to be taken in a very narrow way, and that's why there is a very clear definition and limitation.
Yeah, and at that point, the executive regulations actually are going to provide more clarification on what is meant by doing the accessible format copy. They're going to try to limit it or make it subject to certain conditions, so it's not as well abused in different ways. So that as well is going to come for the executive regulations. They'll cover that as well. One final point on the fair use is related to reproduction of a digital copy. So there's an additional provisions in the fair use that basically allows for making a reproduction of a digital copy if it's incidental and necessary, and as long as it's been obtained legally. This was added as well, so that makes room for a little bit on the digital space as well.
Yeah, and on that point, actually, the law is not really clear as it is. It can include several interpretations, but we don't want to go there because we still don't know how this is going to be
interpreted. And we don't want to overwhelm you as well. So, but again, I mean, we will come back, I mean, on these issues on what's it's meant and what's it's interpreted. Yeah.
On the point of the enforcement of copyright, as you know, generally for the enforcement of intellectual property rights, there are always several options, whether it is precautionary or provisional measures, customs, criminal actions, or civil action. These are normally for any intellectual property rights, you would find these 4 options. For the precautionary measures, it is basically what you can do at the beginning to prevent the infringement or to stop the infringement in a quick way before filing a substantive action. So this was already available in the old law. It is there. The new law has some changes as to what you can request or what the right owner can request in terms of measures to be taken. So basically, the measures are to request the suspension of the publication of work, also the seizure or attachment of the original work as well, to have a report proving the public performance. And they added something really interesting, which is the attachment of the revenues of the publication or of the performance. This wasn't in the law as the attachment of the revenues, but it was more of proving these revenues. You would have a report detailing how much are the revenues, and that's it. But it's not attaching these revenues. I think this is really a good thing, because sometimes, the damage is usually that you are using or you are gaining revenue that you should not be, because you're not authorized to use the work. So I think this is a good option, but we don't know how this is going to be in practice or how easy for this to be done. The precautionary measures are usually filed with the judge of urgent matters, and it is done as an ex parte. So basically, you would not notify the other party, but you have, if it was granted, if an order was granted by the judge, the owner should file a case in substance within 20 days. I think in the old law it was like 15 days. So this is just an increase of the time period for filing the substance case. We hope to see more of these precautionary measures or like summary judgments in terms of copyright. I haven't seen much of that during our practice, but we hope to see more of it. In terms of the customs, of course, this is one of the enforcement options available, which is basically the customs authorities may stop the clearance of any shipment that includes products that has copyright infringement. The stopping the clearance can be based on a request from the right holder or from the customs on their own. This is as well was addressed in the previous law, so there is nothing new in that aspect. The criminal actions still the same. It's possible to file a criminal action with the police or with the public prosecutor, and then it will be addressed as a criminal to the criminal court, and a decision will be issued. The civil action, as a matter of fact, it is the seeking compensation, basically for the infringement of copyright. It is interesting that the old law did not address this specifically. However, we used to rely on the general rules of the law. Basically, it's a compensation for a tort. So it was already addressed through the general rules, but now it is mentioned clearly under the copyright law. It is interesting that it is mentioned as the owner of the copyright or the right holder who can request for the compensation. There is no definition for a right holder under the law, so it is not clear whether this means the successor or licensee, for example, does it cover it or not. But in any ways, the general rules of the UAE laws would apply, and this is actually specifically mentioned in the law that the general rules will apply in terms of the seeking the compensation.
Yes, okay. Well, we've had some increase of penalties in terms of crimes. So the crimes themselves haven't changed in that it's enumerated the same way they are, whether you're unauthorized use of any financial moral rights in whatever way, such as using, manufacturing or importation without legitimate rights. All the kind of infringements that were predominantly in the old law is still the same in the new law. The changes that we have, and we've just highlighted the differences, is the changes in terms of penalties. So for example, we have fines starting from 10,000, instead of it being 50,000, it's now 100,000. And for the manufacturing importation infringement, it's between now the minimum fine as well has increased from 50,000 to 100,000. The maximum fine has increased from 500,000 to 700,000. Not too much increases, but there's some increase, so it's better than nothing. And as well, the using computer programs without permission, the fine has increased as well. The minimum now fine used to be the maximum fine, so that's actually good. So the minimum is 30,000, the maximum is 100,000. That's a little bit of a higher increase related to computer programs. So we're back again to our same point of smart applications being covered in several articles, increasing a little bit more the fines here. So these are basically the changes with regards to the penalties.
And I think also, Miriam, in the event of like repeating infringement, I think the fines may reach up to 1 million dirhams, and I think there could be like a closure of the business, I think, for a maximum of 9 months. So, it's really very good. And this is, again, one of the issues that we always have addressed and discussed in terms of the deterrent penalties. That when you have a penalty, it has to be a deterrent. And, because this is why there is a penalty. Well, I think, again, there will be a scope that we would like to see maybe from the judges, because, there is a maximum and there is a minimum.
Yes.
And
We hope they use the maximum.
exactly, because the current practice that it is always the minimum, and it is never at the maximum or in between.
Because in the previous, what is 10,000 dirhams basically in a violation? If I'm running a really sophisticated infringement activity, and 10,000 dirhams is really nothing. I mean, it's obviously there is a possibility of imprisonment, but Russia is right. I mean, if you don't have teeth in terms of penalties, people will still keep infringing. And so we were hoping for the fine to be maybe doubled, but it's not the case.
But also, Mariam, on the computer programs, I think, again, 10,000 or 100,000. I know that you work a lot in terms of enforcement of software, and you know exactly the losses for software companies. Maybe you can just highlight that.
Yes, so basically, absolutely. So we were on our anti-piracy project. Basically, the losses are much more in terms of violation of anti-piracy, the loss of business of all the companies that are downloading without authorization computer and software programs is much more than the amount that we are seeing. First of all, they were dollars, so I mean, you just it's much more. I'd say even 5 or 6 times more than this amount of penalties.
It's usually the license fees, because sometimes it is very specialized softwares that are being used as professional software, so the license is really high.
It starts with $25,000 to $30,000 up, because it's for sophisticated industries as well. And so when they actually find that the fines were just between 10 and 30,000, I think for the infringers, for them it's like, okay, I'll take a hit on that.
Yeah, instead of paying the license fees.
Checking in terms of time. Okay, we have a final slide here.
Yeah, we can. We're good on time. Okay. So there are other changes. Basically, what we have mentioned are, the major changes that we have seen with respect to the copyright law. But there are other changes. Some of these changes, as Mariam called it, actually, is cosmetic. So basically, there is just kind of rearrangement, redrafting of some articles, which is actually really very good. So for the neighboring rights, Mariam?
So the neighboring rights, basically, I mean, the major, it's as we said, it's cosmetic. It's just that initially, the holders of neighboring rights have the right to prevent, say, I have the right to prevent Russia from doing certain rights, but the provision didn't give me the right to have those actual rights. So it was a term of interpretation. If I can stop Russia, that definitely means that I have those rights. So the law wanted to stop this whole debate and actually gave explicitly those rights broken down, just to make it clear, just so then there is no debate as to whether or not do the holders of neighbor rights have those rights or not. So it's pretty much just to clarify an ambiguity in the previous law. So that's one of the things.
Yeah, but it's not a major change, but I think it's really very good to have it really very clear that performers have the right to rent their work, or they have the right to license, or the publication of their rights, and to make it available to the public, and not just the right to prevent others. So I think it's the same, I think, for the broadcast as well, and the producers of
so basically, on the whole, for the neighboring rights, it just clarified it. And another point as well for the photographs, not major changes, meaning that it was always there in the previous law, that basically you have to be really careful when you took a picture of an individual in that image, and you have to have the consent to have that image with you, and unless this image is taken in a public place or in a public event. But now they've added audiovisual recordings as well, obviously to cater for all the TikToks and all the other videos there. So I think this is nothing new, other than the fact that they've added as well to protect the privacy of the individual depicted in audiovisual recordings.
Yeah. On that point, I think, and we always, Mariam, link it with the privacy, and this is actually where it comes from. Although you are the photographer or the videographer is the owner of the copyright, there is still kind of limitation on their rights in terms of publishing these photos, and they need actually the express consent exactly of the person in that picture.
And there's the one catch-all phrase that basically says in all events, as long as it does not tarnish the reputation of the individual captured in that image or video, that's important. They'll get into a lot of trouble, but we won't, that's for another time.
Okay, yeah, and we also noted that the new law has established a grievances committee. The grievances committee will consist of a judge and two other members who will be appointed by the Minister of Trade. The jurisdiction or the authorities of the grievances committee is to look into all challenges to the ministry's decisions related to copyright. As a matter of fact, we're not really clear into the need for this grievances committee. Because with copyright, it's not the same as trademarks. There isn't many decisions that would be issued by the ministry. We don't see the actual benefit for having a grievances committee. But anyways, this could be a very good thing. If there is a decision issued by the Copyright Office in respect of a copyright application, then the challenging this decision will have to go to the grievances committee. It is good that the grievances committee will have a judge, and this is actually, it gives it more credibility, someone who can actually, be able to make decisions on legal points.
And I think similar to the trademark matter as well, you skip the first, so if you want to appeal from the decision of the grievance committee, you actually go straight to the Court of Appeals.
Yes.
So you actually skip the process of the court of first instance, which is interesting and significant. It's the last point.
Okay, and the last point that we would like to highlight, and actually this was at the very end of the law, that this copyright law would apply to national carriers like aircraft, ships, and trains. This law would apply to it. This wasn't in the previous law, but it is now, so basically we would know what is the law that would apply to national carriers. Okay, I think these are the main changes. As I said at the beginning, it is an enhanced version of the law. It is not a full change of the copyright law, and this is a good thing because it just addressed some gaps that we had in the practice. And I think this is a good thing when you feel the legislator is actually listening and addressing the issues that has been always addressed throughout the practice and the application of the law. There is still it's a new law, so basically we still need to see how it's going to be applied. We are waiting the executive regulations. We don't know when it is going to be issued, but we hope that with the executive regulation, we will have some clarity on some of the
we'll be back for another webinar on the executive regulations. So right now, we have time for some questions. So we're just going to
let me see what questions are there.
Q&A. Because we're getting questions in Q&A and in chat.
Okay, so we have a question here on the assignment of the future work. Okay, this is
a lot of people are really happy with the assignment of future work.
Yeah. Well, I think maybe I'll need to mention this. With the assignment of future works, it was tricky under the current law. The old law. It was tricky because it was actually specific to the authors.
Mhm.
So it says the future works of the author cannot be assigned. So basically, this could be interpreted in a way that the performance rights, or like the owners of neighboring rights can actually assign their future works. And we had actually one of the cases where the court adapted this interpretation. We really don't know how much this is going to be the same, because it's the same position actually in the new law.
Okay, so we will click now on the formal Q&A. Okay. We are reading them as
okay, so we have a question, and like, does the concept of work made for hire still apply to vendor agreements, so that copyright ownership is not automatic vested in client?
We would think so.
Yes, it is the commission work.
It's the commission work. So if the vendor agreement, to the anonymous attendee who posted their question, so if the concept of work for hire, if the vendor agreement is a commissioned work as well, I mean, it would apply. So I see that just to make sure that everyone is aware in terms of vendor agreements is considered a commissioned work. It would be if it's a commissioned work.
If it is commissioned, yeah. Okay, does this law apply to free zones? Yes, of course, it does apply to free zones. Because it's a federal law, so it covers all free zones except for the DIFC, because it has its own laws, and it does actually has a copyright law, specific copyright law. So the law does not apply to the DIFC, which is the Dubai International Financial Center. And I think most of the changes that are made here in the new copyright law are actually the what the DIFC copyright law actually addressed within it.
We have another question in terms of
okay, I think that's it. If anyone has any other questions? Okay, we have another question.
Okay.
Oh.
Yes.
Okay, on the collection agencies of music, well, this is a very, very good question, and actually this is something everyone is looking for. There is nothing new. There is no update on that. It is still the same position. Where collection societies has to be or has to obtain a license from the ministry in order to be able to undertake the activities of the collection societies. We know that there is a lot of talk about it and a lot of pressure to have these collection societies in the UAE, but until now the position is the same. And again, the new law refers as well to the executive regulations with respect to the collection agencies. So we will be waiting for that as well.
Yeah, it's a point of a lot of discussions that we've had in the past. Yes, so there's another, because we have a few questions coming up, but I think we have time for another one. So basically, in terms of, yes, it does actually apply. So may not be specific new law, but does the copyright law recognize computer software and specifically computer games as a copyright item by itself? Yes, basically, it's always been the case. Under the enumerated in Article 2, you have computer software, which includes object code and source code, is covered by copyright. Or is it a software right under UAE law? It's covered confirmation that obviously computer software, which includes computer games, are definitely covered under copyright.
It is not mentioned in the law as games or computer games would be considered on its own as a work.
Mhm.
So basically, you would have to look at the underlying, which is like, there is a software, so the software will be protected as copyright. And then, the other elements, for the game, which is, the description of the
icons
game,
and
the
description of the game.
exactly.
Yeah.
This would be
Yeah.
protected separately.
It's a layered right, and actually we have a case about computer games, and definitely you have different layered IP rights pertaining to those computer games. So it could be the underlying work, the code that was written, and as well you can even add to that the icons and different matters. So yes, these are definitely protected under copyright law.
Okay, I think we can have one more question.
Yes.
Okay. How can I protect my work if it will be subject of a partnership agreement funded by the other party?
Mhm.
The work is already done before the agreement. Okay, this is a very good question. Well, it is basically, it's an agreement now. So it depends on what you want to achieve of this agreement, for both parties. So basically, if the other party would actually get the work, they are paying the amount for them to have full rights of the work, so that the creator will not be able to use the work or to license it to other parties, then this has to be clarified. If you want to protect your work, you have to make sure that this is not the case, that you do not assign the copyright in the work. So basically, you will just give them the license, and the license has to be very limited to the scope of the agreement. It has to be very limited. It has to be limited with the time. It has to be limited with the jurisdiction. So there has to be really very strict conditions for the license.
I think we're exactly on time now.
Okay.
We've managed to answer most of the questions.
Well,
yeah.
Okay.
So, but anyways, if there are any questions, you can always send us by email. We're definitely going to have a repeat of this session once the executive regulations are out, or actually once we have more cases on interpretation of the law.
Okay.
You still want to answer another question, I think.
No,
Okay.
No, I think we can't answer more questions. We don't have time.
Yes.
So thank you all for your attendance. And again, as Mariam mentioned, if there are any questions, please feel free to send it to us, and we will be happy to answer it. And please join us next week. We will have our colleagues who will be talking about the new trademark. So it's going to be really interesting. Thank you.
Thank you. Bye.